Equity skimming is a crime. So it is a criminal offense. And it generally involves two scenarios. So the first scenario is where a property is taken subject to the existing loans, and the purchaser collects all of the rent from those loans, but fails to pay the existing lien holders or other obligations with respect to the property, and then the property ends up in going through foreclosure. So they basically have pocketed, they've rented the property, they've pocketed the rent, but they've not paid the obligations with respect to that property. The second involves purchasing property subject to the existing loans and then refinancing the property or doing an equity line of credit on the property and pulling cash out, either based upon their own ability to qualify for financing or through some form of straw buyer, not buyer, borrower, straw borrower, and they pull all the equity out and then they stop paying and the property forecloses. So let's break those down a little bit. So first, when it comes to collecting of rent where a property has been purchased subject to, there's two types of statutes that apply. So the first is federal law, and that's 12 USC 1709 2, which applies to any type of property that's purchased subject to the existing mortgage loans on the property. And those mortgage loans have to be, for the federal statute to apply, those mortgage loans have to be federally insured mortgage loans. So federal law is only going to apply when the loans are federally insured. And so assuming you have an FHA, a VA, a Fannie Mae, a Freddie Mac loan against the property and you purchase it subject to, federal law is going to kick in. And federal law basically says that if you've purchased the property and the loan, the federally insured loan is delinquent or becomes or is in default and becomes delinquent or in default within 1 year from the date of the purchase, you're going to fall under the statute. And in that case, you cannot collect the rent and not pay the mortgage loan. So if you purchase a property subject to, and it is either in default or it later becomes in default under a federally insured loan, and you collect the rent and you don't use the rent to pay the lender, then you've committed equity skimming, which is a criminal offense under federal law, and you're going to be in violation of this statute. I'm going to read you basically the exact language because I want to talk about, thoughts on structuring, dealing with these types of subject to transactions. So if you fail to make payments under the mortgage or deed of trust as they become due, regardless of whether you're the purchaser obligated under the loan and you apply or authorize the application of rents for your own use. So let's talk about structuring here of subject to transactions, right? So when you purchase a property subject to, there's three options for if you want and you should intend and mean to make payment to the mortgage lender to avoid, coming under this federal statute. So there's three options, right? There's the first option is to make the payments directly to the mortgage lender. That's probably the surest because the ability to make those payments sits with you as the buyer. And so you have the ability to make those payments. The second is to set up a loan servicer, and then the loan servicer should be obligated, and it should state in the purchase contract, or if you do a wrap, which I always recommend for subject to transactions, you do a wrap, it should be in the note that the servicer is obligated to take those payments and first pay the mortgage loan on the property. And then third, you have the ability to write checks to the seller on a wrap. So you can send it to the seller because the seller essentially is the lender under a wrap agreement under the note, and that note should say that the seller is going to make those payments to the lender. But what happens if they don't? You may have an issue here with the statute. So my preference when you're doing subject to transaction is either to make the payments directly to the lender or make them to a loan servicer. I never recommend, nor in my opinion, should you ever make the payments directly to the seller with the hope that the seller is going to actually pay the lender. Uh, Moving forward with the payment of rent to satisfy the mortgage loans when you purchase a property subject to existing liens. There are states, Arizona is not one of them that has a specific equity skimming statute, but there are states such as Colorado that have very specific statutes that address equity skimming, and in particular, the use of rents to pay existing mortgage loans. The Colorado statute is a little different than the federal statute because it does not require that the loans that are for which the property is being taken subject to be federally insured. So they could be hard money loans, they could be other types of financing, but they don't have to be federally insured. And then here's probably the most significant difference between Colorado and the federal statute is it also includes amounts owed to a homeowners association. So if you go and you purchase a property and the homeowners association fees are delinquent, or they become delinquent in Colorado, it's 18 months after the purchase, they become delinquent within that first 18 months, and you're collecting rent and you're not paying the HOA, that is considered in Colorado anyway, equity skimming, and that's a felony offense. It takes it a step further from, dealing only with federally insured mortgage loans to any loan plus HOA assessments and dues and amounts owed. So that's pretty, significant and something that a buyer needs to watch out for. So any state that you're doing business in, you need to consult with a real estate attorney in that state. Make sure you know for sure exactly what you can and can't do with respect to creative financing subject to transactions. And then the final thing that I want to talk about, and I addressed it generally before, which is the idea of purchasing a property subject to, and then doing some type of later financing and pulling out the equity on that. There's no state or federal law that specifically addresses that, but state and federal law enforcement have used a statute that you can find both in the federal statutes as well as state statutes, which deal with schemes and artifices to defraud. And those basically prohibit any person from engaging in some form of scheme or artifice to defraud. And then there's also consumer fraud statutes that prohibit taking advantage of a consumer. And the schemes that federal law enforcement has and even state law enforcement has pursued for quote unquote equity skimming is where a seller or a homeowner is in default. The buyer comes in and says, "Hey, I'm going to help you out. I'll bring the loans current. I'll purchase the property, or I'll take title to the property. You can rent the property from me. And in addition to renting the property from me, I will give you an option to purchase the property." So they give them an ability or make the claim that they have the ability to purchase the property. And then they go and either using their own credit, or they go and maybe transfer title to someone else who can obtain some form of refinancing. They go and they obtain refinancing and pull out all the equity of the property. And then once the loan is in place, equity is pulled out, they walk away, and the property ends up in foreclosure. And then the seller or prior owner who thought that they would be able to rent the property, who thought that they would be able to later repurchase the property, is out because it's foreclosed. And so they can no longer rent it. They can no longer basically purchase it under their option. And so they've used law enforcement's used the general statutes dealing with schemes and artifice to defraud to pursue that type of equity skimming. When you hear equity skimming, that's what it is. And it's something to always be aware of when you're investing and working with investors, working with homeowners, with lenders. You want to make sure that you're on the right side of these statutes and you're not even unknowingly causing a violation or breach, because there are criminal penalties and they're fairly significant if you're ever convicted or charged with equity skimming.